Thank you for hearing my testimony tonight. I'm here in support of these two bills because the current process of adoption for LGBTQ families in Rhode Island is unwieldy, expensive, drawn out, and invasive. Family law exists to protect children, and the current systems for establishing parentage and obtaining confirmatory adoptions violates this principle and leaves our children vulnerable. My daughter June, who's 8, is a much wished for, planned for, and loved child. Her other mom, Hillary, and I traveled to Washington, D.C. to marry as soon as same-sex marriage became legal there, in part because we wanted to strengthen our claim of joint parentage for the child we wanted to have. We planned, attended, and paid for the reproductive treatments that resulted in our daughter together. We attended prenatal appointments, decorated a nursery, and told our friends and family together. We decided to name our baby after Hillary's grandmother, June, and my grandmother, Marie. We both applied for maternity leave so we'd be able to take care of June after she was born. We compared our insurance plans to see which one of us should cover the baby, but we found out that Hillary's insurer wouldn't cover June because we wouldn't be able to offer enough proof of Hillary's parentage once our daughter was born. After 2 uneventful trimesters, I became very sick with preeclampsia and was admitted to the hospital in my 27th week of pregnancy. I was on hospital bed rest for 2 weeks. Hillary and I scrambled to prepare our second parent adoption paperwork during that time. And I submitted, with my letter, I submitted the 18 pages of questions that Rhode Island adopters, including second parent adopters, are asked to complete. And I apologize to the chair because there's also a typo in your name in my letter. So, sorry. I wrote the answers to these required questions from my hospital bed. Hillary wrote her answers while managing our household, a full-time job, and visiting the hospital daily. When I became too sick to continue the pregnancy, I gave birth to June at 29 weeks. Hillary was in the delivery room with me, and after June was taken to the NICU, Hillary was the first person to hold her. I spent an additional 5 hours in surgery and recovery, and during that time, Hillary was June's only conscious and functional parent. Despite the fact that Hillary acted like a parent, that we both believed she was June's parent, and that there was no one else who could claim to be June's parent, legally, Hillary was a stranger to June. Hillary was allowed in the NICU only at the discretion of the hospital staff. She could not make any medical decisions for our 2-pound, 3-ounce baby who required intubation and other medical interventions in those first 12 hours of life. All of that was done at the discretion of the hospital staff. June's birth left us with many painful what-ifs. What if we had disagreed with the doctor's choice of treatment? What if there had been medical decisions that required our input? We wanted our baby to have aggressive treatment, even if there was only a small chance that she would live. And, that's not necessarily what the medical staff would have chosen if we'd not been there to direct them. In those cases, June would have been without a parent to advocate for her because the one parent capable of making those decisions was not acknowledged as her parent. I know our story is more dramatic than most, but it shows the real gaps in current parentage laws and the need for these new laws and reforms. June spent 77 days in the NICU, and our second parent adoption journey encompassed 87 days. During that time, we balanced days and nights in the NICU, work, adoption paperwork. Our lawyer traveled to labor and delivery where I signed paperwork related to June's adoption. One of the effects of medication I took to protect June and myself during delivery was an overall weakness of all the muscles in my body. So I signed paperwork while I couldn't focus my eyes to actually see the words in the documents I was signing. We answered extensive survey questions, asked our friends and families for letters attesting to our good character, and we paid $3,000 for the privilege of doing that, and that was in a year where our medical expenses equaled a third of both of our salaries put together. Completing our adoption required us to bring our medically fragile premature infant to court. June's court date at 10 days out of the NICU was her only outing in her first 3 months at home, aside from doctor's visits, because we were told by the NICU staff not to take her in public places for fear of infection. The current process for securing parentage rights for families like ours in Rhode Island creates unnecessary barriers and may prevent families with particular vulnerabilities, families like mine with medically fragile children, low-income families, families who have had negative experiences with courts, from completing the legal process to protect their children, and families like ours exist. I hope you'll all vote to support these bills. Thank you.